Hello, everybody. My name is Guns and Cafe, and I will be entertaining you for the next 30 to 45 minutes. I've been gone for a little bit. I had some vacation, time with the family, and I decided to take a break from uploading. But here we are. During these 2 weeks, a lot of stuff has happened. Even Mr. Bovino retiring, but the appellate courts and the SCOTUS are seemingly trying to bring things back into normalcy and reality, um, and trying to tell all these pro open border, pro UN, pro World Economic Forum clowns that the American people are not going to take it anymore. We want a secure border, and we want the people that are here that have entered illegally, that have overstayed their visas, to leave, to go. That's what we want. If you came here legally, fantastic. If you went through the process, that's amazing. But just because you one day woke up and decided to say, well, you know what? I'm just going to go walk 2,000 miles and just break into that country. And you know what? When I'm there, good luck getting rid of me. No, no, homie. That's not how it works. It's not how it works. All right. So, uh, as I was saying, SCOTUS and the Federal Appeals Court just delivered massive wins for ICE, border security, and American sovereignty after years of activist judges blocking enforcement and forcing catch and release chaos. The tide is turning. Mandatory no bond detention is back. Courts must defer to immigration judges on asylum denials, and turnback policies at the border are gaining ground. No more catch and release. No more OREX and O soups just because things have been, the courts have decided that enough is enough. So this is an interesting case, and this is the asylum case, if I'm not mistaken. Let me go. Let me see if this one. Let me see if this is the one for the lady that decided. No, this is the one. This is the asylum one. So this is the asylum case that is this the one that Bondi had to do? Let me see. I'm trying to find the one that it was so. Here we go. Here we go. Supreme Court of these United States. So this is the case that deals with the refugees, right? People just, or as um, AOC decided, or some people might call her occasional cortex, says used to talk told Tom Homan a few years back, uh, entering legally is not a crime, and seeking asylum is not a crime. I remember that. Well, entering illegally, as everybody knows, it is a crime under 8 USC 1325. And just because you're an asylum seeker, because this is how they do, they play with the words. Just because you're an asylum seeker, that doesn't automatically mean you can stay because you're seeking. No, you can. Nah, we're not doing that. So, so here's the thing. So they say under the Immigration and Naturalization Act, the government may grant asylum to a non-citizen if it determines that he is a refugee. Now, this is key because a lot of people have been told that asylum is just basically rubber stamp, and you just have to come here and say that you're persecuted in your country, and hey, he's an asylum seeker. He needs to stay because he's filing for asylum. You can't send him back. It's like, nah, homie, that's not how it works. So this person, which was Umberto Douglas Humberto Orias Orellana and his wife Zaira Ileana Gomez Mejia, and their minor child Ge Yuji are El Salvadorian. You know, Salvador was pretty rough a few years back, but now that Bukele is there, he decided that enough is enough. I put a bunch of gang members in prison, and now El Salvador is the safest country in, well, actually, um, North, Central, and South America. So why wouldn't you go back to the tropical paradise that is El Salvador? So this is the person's claim, right? So listen to this story. The story goes to which this person has no evidence to support. He just decided to come to the U.S. and be like, hey, you know what? I got a cool story. I got a cool story. The cool story is that this hitman, this sicario, wants to kill me. That's his story. That's his claim, right? So he says that testified that he was being targeted by a hitman in El Salvador. When did he tell Bukele? So he says that he came in the United States without authorization on 2021. Bukele was already president of El Salvador and, you know, locked up everybody. So if you were so afraid that a hitman in El Salvador was going to kill you, all you had to do was go to the cops in El Salvador and tell them, hey, this guy's trying to kill me. And the Salvadorian police, under the direction of Bukele, would have found that guy and stick him in CCOT. But no, you decided to come to the US, right? Spend all that money, come over here, right? So went to the immigration judge with his story. The judge found the testimony credible. Well, I kind of believe you. It's credible, but it did not establish past persecution or well-founded fear of persecution under the INA. It's not what the judge feels. It's not what AOC feels. It's not what Hakeem Jeffrey feels. It's not what your crazy aunt that has the blue and green hair that's always screaming at Christmas and all family reunions that has TDS. It's not what they feel. It's what's under the INA. Everything else is bullshit, right? So then he appealed, went to the BIA, and they appeal, and I'm sorry, and the BIA said, and the First Circuit also said, nah, bro, no, this ain't working for you. So the INA requires application of substantial evidence, standard to the agency's determination whether a given set of indisputed facts rise to a level of persecution. Right? So then we go on some sections as to why, as the scope of the administrative foundings. And let me see where I found it here. I was reading this earlier. Though the courts of appeals apply varying standards, the court has already concluded that the persecution determination, including both the underlying factual findings and the application of the INA to those findings, receives a substantial evidence review. You can't just show up and say, "Hey, I was in this. I was in Guatemala. I'm from Guatemala, and this dude said he wants to. There's a family feud, and my cousin said that this farm is supposed to be their farm, and they want to take our land, so he's gonna come kill me. So I'm leaving to the United States, and I'm afraid to go back." That's a personal problem, bro. That's not persecution. That's a personal problem, right? So the court rejected the petitioner's arguments, so that a new review should apply because it requires deference for finding of fact, and no subparagraph explicitly address the mixed questions of law that is the determination. So at the end of the day, they told him, you have to go. And this is the beauty of this, right? This is a unanimous decision by SCOTUS. And this is even better. They had Jackson, KGB, delivered the opinion. They had her write it. You know, she was mad. Oh, she was mad. But she had to write it. Justice Jackson delivered the opinion of the court. Petitioners Humberto, his wife, and the kid sought asylum after entering the United States without authorization. So from the get-go, they did it the wrong way. An IJ denied their application, ordered them deported. They didn't determine persecution or establish a well-founded fear of future persecution, right? As required under the INA. Again, not what they feel, not what they like, not what AOC thinks about it, not what Chuck Schumer thinks about it, and everybody in Minnesota that's out there doing crazy stuff. It's what the INA says, right? The Court of Appeals, then he appealed to the Board of Immigration Appeals, and then he went to the circuit court. Then he went to federal court, and even they said, "Nah, bro, we the judge's decision was the right decision, right?" So here's the thing: they entered without authorization. Then the government, soon after they arrived, illegally, the government put them with notices to appear in federal immigration court for a removal hearing. And why am I talking about this slow? A removal hearing. When you go to immigration court, as these people are saying here, your immigration court is not stay here court. Immigration court is removal proceedings, is we're trying to get you out of here court. So the burden is on the person, on the alien. So whenever you see all these people saying like, oh, they arrested the people at the immigration court, where's the due process? Well, because they are in removal proceedings, if the judge orders you reported right there, or the judge dismisses your case, meaning dismisses your asylum petition, they can take you into custody. Why? Because you still gotta go through the removal proceedings. You finished the asylum part. Now you on the going home part, right? Maybe those people had an order to expedite removal already, right? Back into custody. So all that crap that you see, yeah. So, but Orellana was the sole witness at the removal hearing. He testified that a Sicario hitman from his hometown had been targeting him since 2016. That year, the Sicario shot two Urias Orellana's half-brothers and vowed to kill every member of his family. Okay, so says he relocated within El Salvador several times over the next few years. And we are going to go here. Let's go, because this is very important. Let me go to a new. I think it's actually 2020, maybe. When did Bukele become president? Let's see. When did Bukele become president? Ba, 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 ba. All right. So Bukele became president on June 1st, 2019. June 1st, 2019. And the person in question, Urias, came to the U.S. in 2021. So Bukele was already president. So he could have gone to the cops and be like, hey, this guy's trying to kill me. So this year, after each move, Orellana was threatened by men who demanded money and warned that they would leave him like his brothers if he did not pay up. So he constantly kept, this is his claim, he constantly kept moving to all these towns. And every time he came to one of those towns, some men were like, hey, we want to kill you. So every town that he moved to, apparently four. The last straw came soon after Orellana's fourth and final move in 2021, where he learned that men had been asking around town about the arrival of any newcomers. Really? Is that while Bukele was basically rounding up all the criminals? That's what happened. Okay. Maybe the story would have held up a little bit better before Bukele was there, but not anymore, brother. So this guy comes to the U.S., enters illegally, then asks for asylum, right? And all he has is what he told the judge. Apparently there are no death certificates for his family. There are newspaper clippings. There are no reports to the cops. Apparently he doesn't have any scars and nothing. He's just like, hey, like, move to all these towns, and these guys people just show up wanting to kill me on all these towns with no evidence. So you have to let me stay here. And the judges were like, yeah, no, bro, not happening. Under the INA, the U.S. government may, not shall, may. A lot of people like shall not infringe. Oh yeah, that's one thing. But may, that's different. Asylum to a non-citizen if it determines that he is a refugee. Key word. What is a refugee? If he is unable, or unwilling to return to his country of nationality because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. Right? So, is he being targeted because of his race? He didn't say that. Is he being targeted against his religion? No. Is he being targeted because of his nationality? Because he's El Salvadorian and there's Salvadorians that want to kill him. So are the Salvadorians trying to kill him because he's Salvadorian? No. Membership in a particular social group. Did he ever claim that he was? No. Or a political opinion. Was he against Bukele, for Bukele, or there's a political thing? No. So you know what? That's it. You're done. Given the dearth of evidence establishing past or future persecution, the IJ determined that Urias did not qualify as a refugee. This is a 16-page, I believe, decision. So, because the Court of Appeals applied the appropriate standard under Section 1252B-A-4B when it reviewed the agency persecution determination for substantial evidence, the judgment below is affirmed. So it is ordered. You donezo, bro. You done. So that was the asylum case. Now we have here, is this the... Yeah, I think this is the one where they decided to let me look for the one about they wanted to tell ICE how to mandatory detention 2053 BP. Okay, let's see. All right, so this is the case in when Trump administration wanted to utilize the mandatory detention policy under, oh my God, what is it? 1225. Illegal entrants. Even those arrested deep inside the US after years here, right, are treated as applicants for admission. Why? Because they went to apply. No bond hearings for the vast majority. So then that has some lower courts that said some stuff, and then they went to the Eighth Circuit, and the Eighth Circuit said, yeah, the administration is right. So you have Joaquin Herrera Avila. So Ranches Sheriff, Freeborn County, eyes. Then you got the American Immigration Council, blah blah blah. Native of Mexico, apprehended in Minneapolis, of course, for lacking legal documents, authorized admission, detained Avila without bond, and brought removal proceedings against him. Yes, because he's here illegally, doesn't have any documents, so removal proceedings. The district court granted Avila's petition for a writ of habeas, and the government now appeals, having jurisdiction under 28 USC, 29 to 53A, 2253A, and we reverse and remand proceedings consistent with his opinion. So he entered the U.S. illegally on, let's see, 2006. So this dude, Avila, let me see if I can get this one. Go back here. Yes. So this dude has been in the country illegally since 2006. Then he gets popped by immigration. And then he has the audacity to say, hey, you gotta let me go. You gotta give me bond. You know, I've only been here basically, when did he get popped? 19 years illegally. So who are you to arrest me and to keep me in detention? No. You gotta let me go. Look at the audacity. 19 years, almost 19 years on the no shit. Hold on. Yeah, 19 years, almost 19 years, almost 20 years on the run. Then he gets popped and he's like, you gotta give me bond. You can't keep me locked up. That's the audacity of these people. Yeah, Section AUSC 1325, making it illegal to enter the United States at any time or place or other than designated by immigration officials, imposing a term of imprisonment. 1325, yes, 6 months. On August 25, encountered Avila during a traffic stop, during which he admitted he had entered. So during the traffic stop, he admitted that he was in the country legally, lacked documents. They arrested Avila on the same day, removed proceedings, issued a notice to appear. The HSC detained Avila without bond while he brought removal proceedings. Avila requested a bond redetermination, who denied his request. So Avila wanted a bond, goes to the immigration judge, and the immigration judge denied his request. Why would the immigration judge deny his request for bond? I'm going to assume that the reason that the judge denied his bond request is because you've been illegally here for like 20 years, bro. What are you going to do if he lets you go? He's going to run. That's what he's going to do. So then he filed a habeas. The district court granted the petition, and then central to the decision of the court was that AUSC 1225, which authorizes detention without bond for an alien who is an applicant for admission if an alien seeking admission is not clearly beyond a doubt entitled to admission. So concluded that this provision did not apply to Avila because he had lived in the country for years without seeking any lawful immigration status, such as naturalization, asylum, refugee, blah, 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 and thus was not seeking admission under the statute. On appeal, from a district court grant of habeas, review the district findings course to the factor for a clear error and its conclusion of law de novo. The case concerns being admitted does not merely mean being in the present United States under immigration law. It signifies having made lawful entry into the country. See AUSC, the terms of admission, blah, blah. Next, describes the government's power to detain. So let me see if I can find the decision. So this, of course, is going to dissent. And this is the dissent. And he is dissenting because this is the dissent. Except for a single DUI for nearly 20 years, Joaquin Herrera had been living a law-abiding life of the U.S. You need a lot. You need a lot of student loan debt to think that way. You need a lot of education to think that way. Except for a single DUI for nearly 20 years after breaking the law and entering into the country illegally and in a continuing crime, because him being here is the crime. So he's been committing a crime for like 20 years. He has been living a law-abiding life. Bro, come on. This the judges that we got? Really? He was stopped for the past 29 years. Avila will have been entitled to a bond hearing during his removal proceedings. The court now holds that Avila and millions of others are subject to mandatory detention under 1225B. In doing so, the court does not rely on recent congressional action governing the detention, but rather engages in a novel interpretation of agents seeking admission. He is here. That eluded the courts and 5 previous presidential administrations. Are you trying to say, Judge Erickson, that all the previous courts and the 5 previous presidential administrations weren't smart enough to figure this out? Maybe. If that's what you're saying, then, So let's go to where are we at? Find the jail. Here the structure. Nah. Congress wanted. Does Avila sequin? I don't want to get to the dissent. I want to get to. Thank you everybody for being here. Okay, so Avila's argument is unconvincing because it is never our job to rewrite statutory text under the banner of speculation about what Congress might have done. Here, Congress could have declined to delay implementation for any number of reasons. Moreover, legislative history is not the law, and we do not inquire to what legislature meant. We ask only what the statute means. What they might say, what they thought, I don't know, let me look into it, what they might feel. No. Because the text here is clear that an applicant for admission is also an alien seeking admission. Yeah. We may not resort to legislative history to cloud a statutory text that is clear. Accordingly, we find that the district court erred in holding that the government could not detain Avila without bond and in granting habeas. For the foregoing reasons, we reverse the judgment of the district court. And then you had what we talked about, the judge that thinks that being committing a crime for 20 years is like the right thing to do. It's a continuous offense. When this bueno, consolidated cases. This is the mandatory detention. Another one, mandatory detention case. This is the Urillanas. We talked about it. The Ultra Lato. This is still a pending decision. Now, this is interesting because um, the issue, this is from SCOTUS blog, right? The issue, whether an alien who is stopped on the Mexican side of the US Mexico border arrives in the United States within the meaning of the INA. SCOTUS coverage blog, blah, 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 blah. Is this straight thing? Let me see. Joint appendix breach. Friends of the court. Circulated series reply of petitioners 2026, 2024. Reply of petitioners. Okay, what's the reply? Al otro lado, California. Al otro lado, a California corporation. Table of authorities. In the decision below, the Ninth Circuit held that an alien arrives in the United States and is so entitled to apply for asylum and to be inspected by immigration officers if he is stopped on the Mexican side of the U.S.-Mexico border. That decision conflicts with statutory text that the presumption against extraterritoriality, can't believe I said that, and Sale versus Haitian Centers Council, it also deprives the executive branch of an important tool for addressing border surges and preventing overcrowding at ports of entry. This court should reverse the Ninth Circuit's judgment. Respondents have no good answer to the plain meaning of the words arrived in the United States. They contend that sections 1158 and 1225 cover aliens who are attempting to come into the United States at ports of entry, but to arrive is to come to the end of a journey, not merely to come near the end. And in means inside, not closed, but is still outside. An alien who is attempting to come into the United States may be attempting to arrive in the country, but that is not the same thing as actual arrival. So I guess they're talking about crossing the river or basically getting caught in no man's land. Is this the right? So let me go and see if there's anything about the extraterritoriality. Wow, can't believe I said that thing. It's amazing. It's 26 pages. Let me see if I can get to the bottom of this. Discuss review the judgment of the court. Okay, let me go to the. All right, here we go. Respondents argue that the executive branch should manage the border using tools besides metering, but the tools that the respondent recommends do not suffice for addressing overcrowding at ports of entry during border surges. So these guys, what they basically want is to let everybody in and figure out later, because when 10,000 people show up at one place, well, you can't keep them in Mexico. No. You gotta let all the 10,000 in, and then we'll figure it out. 20 years later. Respondents suggest using expedited removal, but that procedure simply allows the government to remove certain aliens who are already in the United States. It does not prevent newly arriving aliens from overwhelming a port's capacity to inspect such arriving aliens while fulfilling CBP's order responsibilities. Yeah. So we're going to flood the port of entry, and then that will, because of course the cartels are not involved in this. And I would like to know how much cartel money is flowing into the. If somebody can answer me that question, how much cartel money is flowing through Congress allegedly? These are my opinions, not the opinions of my employer. Through lobbyists and NGOs that that donate, or a number of other corporations. Respondents also suggest initiating the asylum process while the aliens are still in Mexico, but they do not explain how officials in the United States could interview or detain the aliens in Mexico. So, good idea, ferries. As a person that I know likes to say, it's a good idea, ferry. I don't need good idea ferries. I need fucking solution. Finally, respondents note that courts may only read and interpret existing law, not make policy. Well, isn't that interesting? And they say, indeed, right? Look at that. So they um basically shot themselves in the foot. Existing law provides that an alien becomes entitled to apply for asylum and to be inspected only when he arrives in the United States. An alien who is still outside the United States has no such entitlement. This, I mean, this has been, I don't know to you, but this has been, we have Jaden Cooler. Hi. Hi, Jaden. How you doing? Thank you for being here. Sorry I couldn't get to your chat before. I'm trying to still figure out running the two screens. But yeah. Um this this if you thought that the first Trump administration in regards to immigration was wild, what um what is going on right now, it's I know this dude who, and this is what I like this and I'm interested in this. I knew this guy. He retired. Now he lives outside the United States. And he sees all this stuff that's going on. And he says, "Man, let me tell you something. If we could always do what this ICE is doing. This is legacy INS, right? We had all the same authorities. This is what this guy is telling me. We had all the same authorities that all these new guys have. We had the same stuff. It's just that nobody cared. Nobody actually wanted to do it or gave us the funding. He said, if they had given us the funding and the personnel that we needed 20 years ago, 30 years ago, 40 years ago, we wouldn't have the problems that we have now. But everybody talked a lot of smack and they kept kicking the can down the road. And now that finally someone decided to say, hey, this shit ends here, everybody's going crazy. And the people that are going crazy are the same people that wrote the laws that allow these Border Patrol guys and ICE guys to do what they're doing. And now they're going crazy. Why? Because they wrote these laws knowing or thinking no one is ever going to be crazy enough to follow all these laws, right? That's impossible until the dude that likes to deal in the impossible showed up. And now, ladies and gentlemen, thank you for being here. I appreciate you. I'll see you guys next week. And as I always say, before that, also go and support the sponsor of this podcast, Enforcement Coffee Company. Look them up, Enforcement Coffee Company, a coffee for people that hold the line. And as I always say, if you liked it, share it with your friends. If you hated it, share it with your enemies.